So I told him that both the Wright brothers and Leonardo da Vinci had incredibly similar Oh, hello. Our first case is John F. Tinker and Mary Beth Tinker, minors, by their father and next friend Leonardo Tinker and Christopher Eckhart, minor by his father and next friend William Eckhart, Bristol Des Moines Independent Community School District. This case was argued on November 12, 1968. The constitutional issues at hand was whether or not the prevention of wearing armbands in schools violates the First Amendment rights of students.
The court will now hear your statements. Will the lawyer for Mr. Tinker please begin?
My client, his sister, and his friend all wore black armbands in order to protest the war in Vietnam. The school cannot be allowed to infringe upon their freedom of speech in this way.
Thank you. Will the representative for the Des Moines School District now provide for its defense?
It is necessary for the student body to abide by the established code of conduct. Our administration cannot risk outbreaks of violence and other conflicts over these armbands, and we should have the right to ensure stability on our campus.
Your arguments have been heard. The court will now make its decision.
And so you see, the entirety of human originality is simply a farce. I'm sorry. The court resolved that the First Amendment protected Tinker's right to wear anti-war armbands, and that the school did not have any evidence that wearing of armbands compromised the school's discipline.
Yes, honey, yes. I'll be home in time for dinner. Okay? I gotta go. I love you. Bye. Hello. I'll keep this one short and sweet. Next comes Gitlow v. New York, argued on April 12, 1923. The constitutional issue at hand is whether or not the states must adhere to the provisions of the National Bill of Rights.
Court will now hear your statements. Will the lawyer for Mr. Gitlow please begin?
My client may have spread anti-government pamphlets advocating revolution, but he took no action against the government, and the Bill of Rights should protect him from any persecution.
Thank you. Will the representative for the City of New York now provide for its defense?
Anyone who advocates violence against the government is violating the law. Freedom of speech should not apply.
Your arguments have been heard. The court will now make its decision.
I'm not going to be able to make it home today. I know I'm never home, but this job is really demanding. I gotta go. Bye. The court resolved that the Bill of Rights did apply to state laws. However, Gitlow's attempts to incite violent rebellion against the government were not protected under the First Amendment.
Then, Hazelwood School District versus Coolmore, argued October 13, 1987. The constitutional issue at hand is whether or not student articles in a school newspaper are protected by the First Amendment. The court will now hear your statements. Will the lawyer for Miss Kuhlmeyer please begin?
My client's school newspaper, The Spectrum, for which my client is an editor, should not be subject to review by Principal Reynolds. The First Amendment freedom of the press protects her right to publish articles at her discretion.
Thank you. Will the representative for the Hazelwood School District now provide for its defense? Serious deja vu here.
The removed articles in question were inappropriate for school publication. The administration must reserve control over its own newspaper, especially when dealing with articles that conflict with the educational interests of the school.
Your arguments have been heard. The court will now make its decision. The court resolved that if the school pays for and regulates the newspaper and has a legitimate pedagogical interest in regulating an article, the First Amendment does not protect them from doing so.
Your idiocy continues to astound me. Your point is obviously demonstrated false by the extinction of the Caliphate Rubenervis. Oh, I'm so sorry. On to Miller versus California, argued January 18th and 19th, 1972. The constitutional issue at hand is whether or not the distribution of obscene materials is protected under the First Amendment.
The court will now hear your statements. Will the lawyer for Mr. Miller please begin?
Yes, my client conducted a mass mailing campaign to advertise his adult business. So what if he violates some minor obscenity code? He should have the right to advertise to anyone under the First Amendment.
Thank you. Will the representative for California please provide for its defense?
The First Amendment should protect ideas and communication with value. Obscene materials cannot be allowed for public distribution. Think of the children!
Your arguments have been heard. The court will now make its decision. Okay, I have definitely said this before.
Clearly your lack of formal education is out of your brain! People put more thought into their bowel movements than those points! Oh. Hello, I'm sorry. The court resolved that obscene materials are not protected, and defined obscene materials as those that depict predefined offensive sexual content and or the lack of literary, artistic, political, or scientific value. Much like your argument!
Maybe if you had a job, I wouldn't have to work these ridiculous hours. Speaking of which, New York Times Company versus United States, argued June 26, 1971. The constitutional issue at hand is whether or not the First Amendment freedom of the press is subject to restriction by executive authority.
Hear your statements, the court will. Begin now, representative of New York Times.
Okay then. The New York Times and other news businesses must be allowed to spread information about Vietnam, the Pentagon Papers, as they have been dubbed, to the public. The freedom of press is more important than executive authority.
Thank you. Provide for its defense, will the representative of the United States?
These papers contain information that is crucial to the defense of this nation and the continued war effort. This is a matter of national and military security the current administration must be able to ensure.
Heard your arguments have been. Make its decision, this court will.
I worked my butt off to keep this household together. You have no right to—
Look, we need to start now.
No! Not yet! And hell no you're getting that coffee table. That was given to me by my grandmother.
We're running on a budget here. We need to go now.
Fine. 1 minute. The court can resolve that the government must prove that the publication would cause grave and irreparable danger in order to prevent its dissemination. And if you lay one finger on that coffee table, I will show you the meaning of grave and irreparable danger.
Oh, you want the credits? 1 second. There's your credits, okay? Bye.